Hi, welcome to Smithline Training. I'm Derek Schweed. Today's topic is selling enterprise SaaS, and we'll be exploring legal issues from the vendor perspective. So if you represent any enterprise SaaS companies who are selling to large corporations, we'll have a lot of tips, tricks, and best practices to make that sales process as successful as possible for you. Before we dive in, a few housekeeping matters. As you know, Smithline Training is not a law firm, and these episodes and our tools do not constitute legal advice or create an attorney-client relationship between you and us. As always, if you've got any particular issues, you should consult with your lawyer for advice. Here at Smithline Training, we follow a two-step training approach. First, you'll watch today's episode. Second, you can join us for a roundtable, either online or in person or in San Francisco, where you can ask questions and share best practices. As always, if you've got any feedback, questions, or complaints, go ahead and reach out to help@smithlinetraining.com. All right, so let's get started. Here we want you to put on your vendor cap. We're going to take the vendor's perspective here, and our job really is going to be to understand what enterprise customers are looking for and give you the tools to navigate the sales process as painlessly as possible. And again, we're going to be focused on the sophisticated enterprise customers that you're dealing with. After all, those are the toughest customers with the most demands, and you're not here for help with the easy deals. Today, we're going to be focused on two key topics that come up in every enterprise SaaS deal. The first is actually, whose form are you going to use? And this is before you get to any single contractual negotiation point. It's actually a crucial business and legal decision that you've got to make that'll set the stage for everything else to come. And of course, as vendor, we're going to want to do everything we possibly can to stay on our own form. And we're going to give you tools to do that through a process that we call Tell Your Own Story. The second topic is winning the toughest deal point in enterprise SaaS, which is data breach liability. So today, we're not going to cover every possible negotiation point that can come up in an enterprise SaaS deal, but we're going to really narrow in on what we think is the most important point. It's often the most contentious point, and often it's the last one to be resolved, data breach liability. We'll explain why it's so important. We'll give you some tips and tricks for negotiating this, and we'll also look at some trends that we see in the market in terms of liability caps. As with every Smithline Training episode, we've got tools for you, so go ahead and download those now if you don't already have them handy. The first is called Stay on Your Own Paper, and that's a toolkit to accompany the first part of the presentation. The second is Tips and Tricks for Vendors for Data Breach Liability. And again, go ahead and get those ready now so you've got them handy. Okay, let's dive into our first topic, whose form to use. Well, we know as vendors whose form we don't want to use. We call customer paper the big hurt. And as a lawyer representing enterprise SaaS companies, we're sure that you've lived through the pain. You're a perfectly nice vendor. You send over a short, sweet, 8-page SaaS form to your customer, in this case, let's say a big bank. And in return, you receive an 80-page monstrosity covering heaven knows what with all kinds of problematic and irrelevant provisions. So what's going on here? Why is customer paper so problematic to use? Well, oftentimes it might not even cover the right products. That big bank's agreement might cover professional services or installed software when you're actually just selling enterprise SaaS. It may have a lot of non-starters from a legal and business perspective, like it says that you'll assign all of your IP to the bank, or it's got exclusivity or MFN pricing provisions. It probably has a lot of customer-specific terms that don't match your actual practices. So even if the form is about SaaS, it's got a lot of bank-specific security, audit, support, or SLAs that simply don't line up with how you do business. Finally, more than likely, if it's a generic form, it's going to be missing the essential terms for your service, the terms that actually allow customers to use, deploy, collect data, and all the other product-specific terms that make your product your product. So what are the results? What happens when you actually go to negotiate on customer paper? Well, it's a major effort just to get to the 50-yard line. And by that I mean, you're probably going through multiple drafts and discussions just to get to the point where you have a saleable document that more or less describes your product. All of this, of course, burns a lot of goodwill between you and the customer, results in much, much longer deal cycles, and we think worse contractual results. So let's take a look at how this looks visually. Take a look at the graphic on screen. We call this the hurt meter, and this represents the difference between doing a deal on customer paper as opposed to your own paper. Now have a look at that big throbbing red area. That is the deal on customer paper. It takes longer and it's a lot more painful. So why is that? What's happening here? Well, what's really happening, like I said, is that you're spending a lot of time and effort just to describe your own product. You're burning all that goodwill, and you're having calls, drafts, and chasing your own tails on issues that maybe shouldn't have been issues in the first place if you'd started with your own paper. Now look at the blue area. When you use your own paper, well, the deal cycle is much, much shorter, and the overall hurt quotient is much less. So, as vendors, of course, we're always going to want to be on our own paper. So, what do? When you're dealing with the most sophisticated enterprise SaaS customers, how are you going to maximize your chances of staying on your own paper? Well, we think the answer is to tell your own story. Let me explain what that means. Telling your own story means explaining your product in a way that reduces your customers' anxiety. This is your best chance to stay on your own paper, and it's going to set the context for the entire deal. After all, if you don't tell your own story, your customer is going to invent one of their own, and guess what? Theirs doesn't have a happy ending. Let me explain what I mean by that. You're dealing with enterprise SaaS customers. These folks are going to have thousands and thousands of vendors, and they've probably had a few bad experiences in that time. They've had data breaches, they've had vendors who just can't stand up their product and deliver. So if you don't tell your story and put your best possible foot forward, the customer is going to start essentially making up the worst case scenario to apply to your product. And that's something we definitely want to avoid. So how are we going to construct our story? Well, that really starts with your contract. And your contract should first show that your product is unique and not generic. And this actually works on a few different levels. One, of course, if you have a unique product and your contract can demonstrate that, that's an argument for staying on your special paper rather than moving to the customer's generic form. More generally, throughout the negotiation process, having a unique product is going to really inform every other deal point, from the warranty to the support to the SLA. So showing that your product is unique instead of generic is going to be really important for you. Well, second, of course, your form is going to need to be carefully tailored to that unique product. And finally, your form is going to need to address the key customer concerns that enterprise customers are likely to have. Now here, enterprise customers are going to be following a checklist, and your form should really help them check the boxes, showing that you've already thought about the things that they care about. At the end of the day, you want to end up with the happy customer, someone who looks at your form and says, hey, it's not perfect, but we can live with this. This is a professionally drafted, robust form that we can sign up to. All right, so how do you actually put this into practice? First, your contract is going to need to describe your product. So we say start your form with a product overview that explains exactly what makes your product unique and how it works. So to write the overview, go ahead and ask yourself, what would a customer of this product want to know? And what do I want the customer legal who's reading this agreement to know? We'll explain this through an example. We're going to take a fictional company called Commerce Tracker, which provides an e-commerce analytics product, and we're going to walk through what their product overview looks like. All right, take a look at what's on screen. This may seem pretty complicated, but we're actually introducing this example to show that you can take a relatively complicated product involving data collection, which often gets customers nervous, and explain it in a way that customers will get comfortable with. So let's just walk through this together. First, what is Commerce Tracker? What is this product in the first place? Well, Commerce Tracker is a SaaS service allowing customers to collect actionable insights about end-user engagement on the customer's e-commerce sites and apps. Customers can configure their projects to collect different data types of their choice. So what's an example of the data you might collect with Commerce Tracker? Well, it could be page view analytics, conversion rates, information about shopping cart abandonments, and clickstream data. Basically all the data that might be interesting to an e-commerce platform. All right, that's what it is. How does it work? Well, all the customer has to do is implement the Commerce Tracker SDKs and scripts on the customer properties, and then go ahead and configure their projects through the Commerce Tracker dashboard. So we've basically just given the customer an outline of what this product is. Now we have to think through, based on that, what is the customer likely to be worried about, and how can I set their mind at ease? Well, from the description, you might have guessed that for Commerce Tracker, key customer concerns are likely to be about data, and especially end-user data, the data that you're collecting from the customer's own website visitors. So how can we disarm those customer concerns in the product overview? Let's look at the next slide. In that product overview, we're going to answer the question, what data does Commerce Tracker collect? And it turns out that the answer is that the customer actually fully controls the data the service collects, including the data collected from end users. Aha, that's really helpful Now the customer knows that they're in control and that Commerce Tracker isn't collecting any data other than what the customer tells them to. Now, customers likely are going to be worried about payment or other sensitive data, especially in the e-commerce context. And right in your overview, you're going to tell the customer, it turns out Commerce Tracker doesn't collect any payment information. It doesn't even collect any information that end users add to form fields on the customer sites. And for good measure, Commerce Tracker prohibits other sensitive data types like social security numbers and just tells the customer outright, don't submit that to Commerce Tracker at all. All right, great. So we've anticipated what the customer's concerns are, and we've done our best to disarm them. And remember, you're including all of this information in the product overview at the very beginning of this agreement. You want the first time that the customer hears about your SDKs or your data tracking to be in your words at the start. That's not something you want them discovering by accident through negotiation. You own the frame here, and you have the chance to put your best foot forward. All right, so what else should you do in your contract? Well, we think that you should otherwise present an image to the customer that you're one of the good vendors. So you're going to include enterprise-grade protections in the form tailored to your own business practices. So take a look at the Commerce Tracker Enterprise Agreement. That's what's happening in the rest of the agreement. So this will cover their performance warranty, their IP indemnity, support SLA, security policy. If Commerce Tracker has Privacy Shield or SOC 2 certifications, they can say so. So basically the idea here is you want to get sorted into the good vendor pile at the customer. Imagine that at every customer there's two piles of vendor forms. One is the good vendor pile where they'll take a look, they'll make a few changes, and they'll sign off. The other is where you've caught the attention of the customer in the bad way. Maybe you don't have a professional security policy or something else has put the customer on edge. That's when you get sorted into the bad vendor pile and get a lot more scrutiny than you want. So again, we want to be one of the good ones. All right, so you're the good vendor. You have a lot of enterprise-grade protections in your form. You've written a product overview that explains your product and anticipates and addresses customer concerns. But what about those customers who still aren't sold and who still insist on using their own paper? Well, for them, you're going to write a business-friendly Use My Form email that explains more about your product and does your best to persuade the customer to stick with your form. Here's what that'll cover. It'll be a customized email tailored to your product that explains your unique product, and this ties back to the product overview that's in the contract itself, and you can consider this even a more business-friendly version of that product overview. Second, you're going to outline all the benefits of using your form, like that it is tailored to your product, and all of those built-in enterprise-grade protections that you've included. Finally, you'll also outline some of the standard processes that benefit all customers, like support, SLA, and security. And by the way, our tools has an example Use My Form email for Commerce Tracker, which I'll walk you through later. Next, your email is going to explain why you can't use the customer's form. And this is going to be really crucial, and it's going to require that you read the customer's form carefully and that you highlight the most objectively wrong terms for your product. So, looking back at this big bank vendor agreement, it's things like this agreement maybe covers the wrong type of services in the first place. It covers professional services or it covers installed software. It doesn't cover your proprietary SaaS service. Maybe it's got those problematic terms like exclusivity. Maybe it says that you're going to assign all of your IP to the vendor. Maybe it has source code escrow, which as SaaS vendors we all know doesn't really make any sense for SaaS. Perhaps it's got customer-specific security terms that don't match your practices at all. So the key here is to really highlight the things that are objectively wrong, like the examples that we've shown. It's not about the finer points of indemnity or the fact that you don't like the governing law. It's the things that make the form the wrong starting place from the jump. Finally, you want to end the email on a high note, emphasizing that your form is really going to be the quickest and simplest path forward for the customer. After all, the customer wants to buy your product, so you need to sell your form as the best way to get that product. It's your form, go ahead and sell it just like you sell the product itself. All right, so quick takeaways. Tell your own story in your form. That means include a product overview, anticipate and disarm customer concerns, and include industry standard protections so that you can be one of the good vendors. Then for the tough customers who still want to use their own paper, send the Use My Form email. All right, so what are the results? Does it really work? Well, the answer is yes. Now you may ask us, what about for the toughest customers, the banks, the insurance companies, and the Fortune 50 corporations? Well, the answer here is you'd be surprised. And if you're ever wondering, should I just go ahead and bite the bullet and use the customer's form? we'd recommend don't forget the hurt meter. All right, so let's take another look at the hurt meter. And we'll look at it from a different perspective this time. Go ahead and look at day one. Well, here it looks like if you insist on using your own paper, that's actually a lot more hurt on day one than using customer paper. And that makes sense. You're insisting on using your own paper, whereas the customer really just wants to get started. Your sales team is putting pressure on you just to sign up the deal and throw the customer a bone by using the customer's paper. So there can be a tendency or a temptation to use the customer's paper on day one. Now, suppose you did that. Go ahead and take a look. Weeks 1 and 2, the hurt starts increasing astronomically. And that's because now you've made that choice and you're stuck redlining a bunch of stuff out of the customer's paper that probably shouldn't have applied in the first place. Now, perhaps by week 4 or 5, you've done that and you're able to focus on the issues that really do apply to your product and that really matter to both parties. But in the meantime, you've spent a lot of time and effort and unnecessary pain doing so. So, like I said, our recommendation is if you're tempted to agree to use customer paper, well, think about the hurt meter. All right, that brings part 1 to a close. Let's talk about part 2, winning the toughest deal point, data breach liability. Now here we are really going to be focused on this one deal point. There's many other negotiation points that can come up with enterprise SaaS. It could be warranty, it could be indemnity, it could be all kinds of different things. And in fact, at Smithline Training, we have videos covering several of those topics. Now, why are we focused specifically on data breach liability? Well, it's because this really is the toughest point. It's the exquisite issue in SaaS. It's what your customers are going to be most worried about, and frankly, what you should be most worried about too. It's also most often the most contentious issue and the last one to be resolved. All right, so let's do it. We think every enterprise SaaS deal has a conundrum. The customer thinks, hey, vendor, this is our most sensitive data that I'm trusting you with. If you had a security breach, why wouldn't you take full responsibility for that? Whereas the vendor on their side, are just from a risk allocation and a fairness perspective, are going to think, wait a minute, unlimited liability on a $200K deal, that could sink the company. No way. All right, so what's going on here? What are customers so worried about? Well, when customers think data breach, they think a parade of horribles. First is the cost. Data breach is just expensive, as everyone knows. Second, responding to data breaches is going to be time-consuming and resource-intensive. It can cause a big damage to the customer's reputation and can also cause customers legal problems of their own through statutory notice and remediation requirements under California law, other state law, and foreign laws. Speaking of which, especially under GDPR, customers are very worried about the fines that can be applied by data protection authorities for violations of GDPR. And here, if you don't know about that, the fines can be up to 4% of the violator's global turnover. Finally, customers may simply just have PTSD. Perhaps they've had a data breach of their own, or perhaps they've had other vendors who've experienced data breaches. And now, all this anxiety that the customer has as vendor, you're going to bear the brunt of that. All right, so what is the good vendor to do? Remember, we want to be one of the good vendors presenting a professional image to the customer. Well, your contract itself should present a robust security offering. You're going to want a security policy that's professional and tailored to your product. You're going to want to cover off EU data if you've gotten there. You may have a Privacy Shield certification. You may have a GDPR compliance plan. Go ahead and reference those. You should include a data protection addendum. And also, if you've got audits and certifications ready, like SOC 2 or ISO certifications, go ahead and reference those as well. Okay, so you've got this robust security offering, but you're still going to ask me, hey, wait a minute, Derek, what should I say about data breach liability? So let's talk that through. The short answer, of course, is that vendors should not assume unlimited liability for data breach. There's no SaaS vendor worth its salt in 2018 taking on unlimited liability for data breach. I can tell you that right now. All right, so how do you avoid it? Well, let's talk through some talking points that you can use as vendors. First, and I want to pause on this one, the customer is the one who's selecting the data to use with the SaaS product. So going back to the Commerce Tracker example, the customer really is in full control of the data that they collect from their end users and how important and how sensitive it is to them. The vendor is agnostic to that. Second, liability could depend on several factors that are outside of the vendor's control in the first place. So there could be a security issue on the customer side, there could be a security issue with a third-party integration point, or maybe in the Commerce Tracker example, the customer never got the proper rights to share its data with Commerce Tracker in the first place. All of these things can result in liability, and it's not the vendor's fault. Third, of course, the vendor takes standard protections to protect the customer data. That's that professional security offering that we just talked about with your security policy and everything else. But, as a matter of fact, the vendor can't underwrite all risk inherent in using an online SaaS product. You're Commerce Tracker, you're a vendor of a great e-commerce analytics tool. You're not also the insurance company for e-commerce analytics. And we've got a lot more details about all of these points in the Tips and Tricks for Vendors tool, so have a look at that when you have a chance. All right, so we know that we're going to want a cap. What cap should apply to data breach as a vendor? Well, first of all, most of your enterprise SaaS deals are probably going to have a general liability cap for garden variety breaches of 12 months fees. Can we go ahead and just apply that to data breach? Sure, that's great for the vendor, but it's going to be tough with those sophisticated enterprise SaaS customers. They're going to be expecting more. So the most common compromise is simply an enhanced cap for data breaches. And this cap is usually going to bear some reasonable relationship to the deal size. So often that could be expressed as a multiplier of the 12-month fees general cap, perhaps 3x, or it could be a fixed dollar amount that, $1 million on a $300K deal, roughly getting you to the same place. I want to add an important word here about how you actually structure your cap. Because when you take on enhanced liability for data breach, you should only do that in a way where it's fault-based, based on your wrongful actions as the vendor, and it involves actual harm to the customer. Let me give you a couple examples of the wrong way to do this. Suppose the customer tells you, sure, I'll agree to enhanced data cap, but I want that cap to cover any unauthorized disclosure of my data in your possession. Now, as vendor, you should ask yourself, well, wait a minute. What about all those other ways that a data breach could occur that aren't my fault? This isn't fault-based, and therefore I shouldn't take on enhanced liability for any unauthorized disclosure. It needs to be fault-based. It needs to be something that I caused. What about another example? Vendor's breach of its security policy. So any vendor breach of its security policy is covered by the enhanced cap. That's also wrong because it's not clear that there's any actual harm to the customer. So the right way to do this is to really marry these two things together. So a proper formulation would be vendor's breach of its security policy that results in unauthorized disclosure of the customer data. So we had that security policy where we included all of our promises to the customer about our security procedures. We violated that, say we didn't take the encryption steps that we promised, and that's what caused the harm to the customer. That's the right way to think about this. All right, now as you're structuring your data breach liability framework, you're going to have a whole bunch of other decision points. We don't have time to go through all of these today, but they are covered in the tips and tricks handout, and I just want to flag them for you now. So you're going to have questions like, should consequential damages be available within my enhanced cap? Should I indemnify for data breach, and should that indemnity be included in the cap? And then finally, should I be covering breach notifications to the individuals affected by the data breach and the cost of credit monitoring for those individuals? So there's answers for all of these and ways of thinking about all of these, again, which are covered in the tips and tricks handout, so please do have a look at that. All right, last point about structuring your enhanced liability cap. I want you to watch out for the confidentiality carve-out. What do I mean by this? All right, as you know, as a lawyer, confidentiality breaches are often going to be carved out of the limitations of liability altogether. So it'll say that the section about confidential information in general is carved out of the cap, and it's also carved out of the consequential damages waiver. Now, at the same time, customer data is often implicitly or by a specific call-out going to be considered confidential information of the customer. So if you have that standard confidentiality carve-out, that can actually result in a backdoor to unlimited liability for data breach for the vendor. So what should you do as a vendor? Well, first, really try to address data breach in one place. To the extent possible, try to get the customer data or breach of customer data security out of the confidentiality section and back in your security section. And then second, as you're writing your carve-outs and your caps in the limitation of liability section, make sure you are distinguishing between garden variety confidential information and data. And oftentimes you just have to say that explicitly. All right, so you've learned how to structure your cap in general, but what should that cap be and what are we seeing in the market? Well, as mentioned, enhanced caps are the most common compromise for data breach liability in enterprise SaaS deals. We took a look at the data over the last few years, and in the vast majority of cases, there is an enhanced cap. Sometimes the vendor was able to get away with a general cap, perhaps of 12 months fees. Other times the vendor did agree to unlimited liability, although, like I said, we certainly don't recommend that. So again, the most common result would be an enhanced cap. And what is that cap going to include? How large is that cap? Well, like I said, this could be expressed as a multiplier of the general cap or as a fixed amount. So say you've got the general cap of 12 months fees, you often will end up with a multiplier of 2 to 5 times that amount. That seems to be the sweet spot based on our review of the data. What about when the cap is shown as a fixed amount? Well, this will really vary. It varies based on a lot of factors, but typically you're going to see that in the 7 figures. All right, a few notes. All of this always is going to depend on deal size and the specific circumstances of that negotiation. Most often when you have more sensitive data, you're going to see a higher cap. Finally, with the arrival of GDPR, customers are very concerned about the prospect of fines under GDPR. As I mentioned, fines for violations of GDPR can be up to 4% of the violator's annual global turnover. So naturally, this is going to result in upward pressure on the caps for customers who are worried about that. All right, so what should you do as vendor? Well, of course, your data breach liability framework is going to depend on your specific product. It's going to depend on the data that you collect, the customers that you're dealing with, and in fact, where they're located. What's important, though, is that you do establish a framework proactively. This isn't something you should decide deal by deal. It's something you should work with your executives and your board to set in advance. Okay, before we sign off, I just want to remind you of the tools that accompany this episode. I already told you a little bit about the data breach liability tips and tricks for vendors. Definitely recommend you take a close look at that. Here I just want to focus in on the Stay on Your Own Paper toolkit. So go ahead and pull that up. We'll take a look. Okay, so this is really sample language from Commerce Tracker, and it's got 2 parts. The first part is the product overview from Commerce Tracker's MSA, and the second is the Use My Form email. So take a look. Again, the overview can be really simple, as you see here. It simply explains what Commerce Tracker is for, how the customer controls the data that they collect, and the fact that Commerce Tracker isn't collecting any of the customer's sensitive data that the customer is most worried about. So it really just explains the product and tries to anticipate and disarm common customer questions and concerns. Have a look in your own product overview. Of course, you'll need to customize it for your own product and your customer base, but hopefully this serves as a useful template. All right, now let's shift gears over to the Use My Form email. And here again, this is simply a business-friendly explanation along the same lines. So it explains what Commerce Tracker is, how you can use it. It also explains, again, that the customer is in full control of the data that we collect and that we don't get any sensitive data in the first place. It also outlines the core protections that are in the Commerce Tracker MSA that benefit all customers, and it's got a placeholder for you to describe why you can't use the individual customer's MSA. Now for that, of course, you've got to read the individual customer's MSA, and you've got to pick out those most objectively wrong things in the MSA to explain why it simply doesn't map to your product. So just like the product overview, of course, you've got to customize this email for your own business and for your own product, but we think that this template is really successful, and we think that you'll benefit from using it in your practice as well. All right, so that brings us to the end. Thank you so much for watching. We hope that you learned a lot, and we look forward to seeing you in a roundtable.